Good evening, everyone. I'm City of Laurel Communications Director Audrey Barnes. Thank you so much for being here for tonight's special information session. It's called Evictions during COVID-19. Know Your Rights. The City of Laurel is pleased to partner with the Prince George's County Community Legal Services to present this vital information for you tonight. Before we begin our program, I would like to acknowledge Laurel City Council President Valerie Nicholas is with us tonight. We also have Councilman Mike Les in the audience, and our emergency manager, Miss Chrissy Cornwell, is here tonight as well. Thank you very much for being with us tonight. As you may know, Governor Larry Hogan has extended the moratorium on evictions until August 15th. But what happens after that? You're going to find out that information and more tonight. The town hall is being broadcast live on Laurel TV and live streamed on laureltv.org, and the City of Laurel government Facebook page is also carrying this event live. We will be taking your questions also by call-in. I'm going to give you the number now, and we will repeat it throughout the program. Don't call now. The phone lines are not open. I will let you know when those phone lines are open, and you can call in your questions from home. That phone number is 240-294-1308. If you get a busy signal, keep trying. We'll get to your question as soon as we can. And we have a small crowd here in the audience. If you audience members would like to ask a question, I'm going to direct you to the side dais here. There's a microphone about midway down, and you can ask your questions from that podium so that our audience at home can hear them as well. And if you prefer, you can also write your questions down. We'll give you a little postcard to write them on, and I'll read the questions to our panelists for you tonight as well. Also, don't forget, write those questions in the chat bar on Facebook Live tonight. So let's get started. Throughout the pandemic, Laurel Mayor Craig Moe has worked tirelessly to protect the health and safety of city employees and our residents. He's also been a huge advocate of getting food on people's tables, and he's been equally concerned about keeping people in their homes, keeping a roof over their heads. And that's what brings us to this event tonight. He has thrown his full support behind this effort. Please join me in welcoming Laurel Mayor Craig Moe.
Good evening, and on behalf of the Mayor and City Council, we want to welcome you to the Laurel Municipal Center for those in the audience. To all of you watching at home on Laurel TV or watching on Facebook Live, thank you very much for tuning in. I want to start by acknowledging and thanking Councilman Keith Sidnor for the work that he has done on the evictions and working with the Mayor and Council to educate us as well. And Keith, again, thank you for your hard work, and thank you for working with the administration. We appreciate that. Let me also welcome Ms. Williams from the County Legal Services of Prince George's County, and to our own Dr. Inubi, our City Health Officer. You'll be hearing from him as well. I want to acknowledge the doc and thank him for his hard work. These past 18 months, we couldn't have done a lot of things without his guidance and support. So, Dot, thank you very much. As I said, these past 18 months have been tough on all of us. We still have a ways to go, but tonight we'll hear from Ms. Williams on evictions during COVID-19, and it's Know Your Rights. This is an important subject. I encourage you to ask questions, whether you're at home, whether you are in the audience, so please ask questions. And this is not just for tenants, but also for landlords, so we want to make sure that you ask those questions. I am pleased again to acknowledge on behalf of the Mayor and City Council our partnership with all of those on the dais here tonight. We want to thank you for your interest and your support on this very important matter. Everyone, again, I'd like to take the opportunity and remind everybody to please get vaccinated. If you've not been vaccinated, please do so. We ask you to practice social distancing and wear a mask as needed. All of us on the dais tonight have been fully vaccinated. So again, we encourage you, when you need a mask, wear your mask. And if you're not sure, you got to ask yourself that, put it on, and make sure you get vaccinated. Thank you all very much.
Thank you very much, Mayor Mo. And before we get to the information on evictions, let's talk a little bit about COVID-19, because given the numbers and what's happening in this community and across the country, we think it's important to keep our eye on the ultimate goal of getting back to normal activities. And so there's no better person to give us an update on where we stand with COVID-19 than the City of Laurel's Chief Health Officer, Dr. Uzo Unegbu. Dr. Yu?
Thank you very much, Audrey. Mayor, council members, all protocols observed. Definitely, like the mayor had mentioned about the COVID-19, definitely is important for us to get our vaccines. The vaccine that we have out there is safe and effective. Millions of people that have actually had their vaccines throughout since the vaccine has been out. CDC is recommending you to get the vaccine as soon as you can. Everyone from 12 years of age up until older is now eligible to get a free COVID-19 vaccine. The three different types that we have out there, one is from the Pfizer, the other one is Moderna, and the other one is Johnson & Johnson. The best COVID-19 vaccine is the first one that is available to you. Do not wait for a specific brand. All currently authorized and recommended COVID-19 vaccines, they are pretty safe. And studies have done extensively on these vaccines. They are effective, and they also reduce your risk of severe illness. As you all know, the Delta strain is out there now, and the numbers have increased. That we have about 83% of the people that are infected actually have not received the vaccine, and they are most of them are actually hospitalized. So as the mayor and the council member and the city officials have been advertising, COVID-19 vaccine is important, so take the shot, Laurel. Thank you.
Dr. Yu, we do have a real quick question from the community. They would like to know, they've only received one of their shots so far, and they're having second thoughts about whether or not they need to get that second Moderna vaccine. What is the answer? Do you need to get both of those shots, or is one enough protection?
Very good question. The vaccine is important, especially for the Pfizer and the Moderna, for you to have two shots. And it's actually structured in a way that the Pfizer one, you have to take the second shot after 21 days. And then for the Moderna is after 28 days. The reason for that is the first shot is just as a primer, and the second one is actually what gives you the immunity. So if you just only have just the primer, unfortunately, you're not fully covered. So you pretty much are going to stand as someone who has not received the vaccine. So we urge you to get both, because once after the second shot, 2 weeks later, you're fully immune.
We are getting another question about the Delta variants. That seems to be the prevalent type of virus that's in the community, those variants.
That's actually what it is. It's a variant that stems from South of America and also from South Africa. But that strain is a virulent type that actually can lead to death. And but luckily for us, the Pfizer and the Moderna has been known to be able to cover for it. Studies are still being worked on about the Johnson & Johnson, if they're going to need a booster shot for that. But again, the goal is get the shot as soon as you can, just to make sure that you don't end up in the hospital, because this variant strain is very virulent.
I have another quick question for you. What about these breakthrough cases that we're hearing about with people who have been fully vaccinated? What is the message?
Yeah, the message on that is that even though they're fully vaccinated, but it's a very small number of people that have actually gotten a breakthrough infection. But if you look at the record, it actually has not led to death. So those are the ones that maybe their immunity did not fully develop when they actually got the vaccine. But remember, it's just a small amount of people out there.
And the important thing that I keep hearing about from the CDC and health professionals like yourself across the country is that if you're vaccinated, if you are exposed, you still will not have the most severe case that you would had you not gotten that shot.
Most definitely, and it will keep you away from being in the hospital.
Thank you. Thank you very much, Doctor.
You're welcome.
We appreciate that. So now we want to get to the main reason we are here tonight. We want to talk about evictions during this pandemic. What has COVID-19 done to the rules and restrictions for landlords? And what do tenants need to know? Councilman Keith Sidnor, who spearheaded this event, is here to introduce our key speaker tonight. Councilman Sidnor?
Thank you, Director Barnes. Good evening, everyone. First of all, I want to tell you how I met Ms. Williams. I met Ms. Williams about 3 years ago. She was doing the same seminar in the community, and I was a newly elected council member, so I went up to her after she spoke and got her information, and we stayed in contact. And maybe about 3 months ago, Ms. Williams called me, reached out, email, and say, she wants to do something for the community. What would we benefit from? So I said, I think we'd benefit better from eviction and landlord and tenant rights. So that's why we're here today. But let me tell you also something about Ms. Williams. She's a Laurel High School graduate, class of 2007. Homegrown here in Laurel, giving back to her community. She also a Hampton University Graduate Institute, right? What's the name now? I know they changed the name. Okay, all right. And she also went to law school in Southern University Law Center. So we got a homegrown person here, went to Laurel High School, a lawyer working in the community, going to give us information about knowing your rights for landlords and tenants. So thank you for coming out, Ms. Williams. Really appreciate everything you're doing for our community, and we're looking forward to your presentation. Thank you.
So good evening, everyone. I'm happy to be here. My name is Kayla Williams, and I'm a staff attorney with Community Legal Services of Prince George's County. I want to thank the City of Laurel for having me here. I think we're going to have a good discussion tonight. So a little bit about Community Legal Services. We are a nonprofit organization. We provide civil legal services. So we have landlord-tenant, we have foreclosure, bankruptcy, family law, anything like that. We also have a same-day representation program for tenants at the Hyattsville District Court. So if anyone has a hearing coming up, if they have questions, or if they have a hearing and need representation, they can always go to the Hyattsville District Court and ask for us. We have attorneys that are there every day. So let's go ahead and get started. We have a very substantive presentation. So I will say, I'll start with the courts are open. They have been operating in phase 5 since April of 26. What that means is they are hearing every type of landlord-tenant case right now. I'm going to start this presentation by going over what the moratoriums and protections are. Then I'm going to move into what the different types of cases that a landlord or a tenant may want to encounter. And this is just a brief overview of some of the cases we'll be discussing tonight. The landlord-tenant cases consist of failure to pay rent cases, breach of lease cases, tenant holding over cases, wrongful detainer cases, and rent escrow cases. And so there are currently 3 eviction moratoriums. We'll discuss those in more detail in the next slides. There's this national CDC moratorium. There is the statewide Governor Hogan's moratorium. And there are also county-specific moratoriums that prohibit certain late fees and rent increases. It's important to know that these moratoriums are not automatic. So we often get calls from tenants that say, hey, I've received a court summons or I've received a notice from my landlord saying that I have to leave. You have the right to raise the moratoriums. However, you have to make some type of affirmative action, whether that's appearing in court and raising the moratoriums, or you can print out the CDC form and give it to your landlord. And we'll discuss the different moratoriums on the next slide. So for the CDC moratorium, it has been extended until July 31st. That means it is set to expire soon. For this moratorium, you can raise it anytime. You simply have to go online and print out a CDC declaration form and give that to your landlord. Or if you're summoned to appear at a hearing, you can bring that to court and give it to the judge or the attorney who's representing the landlord. It's important to know that none of the moratoriums are going to stop rent from being owed. So as a tenant, it is still your obligation to pay rent as you can. It is simply delaying an eviction. It's also important to know that in order to raise either of the moratoriums, you do have to show that you have suffered a substantial loss of income that's COVID related. So for example, if you've lost your job, if you've had to take care of a relative, you couldn't work, things like that, those could be grounds to raise either the CDC or Governor Hogan's moratorium. Again, if you are summoned to appear at a hearing, you want to make sure that you bring a copy of the CDC declaration form to your hearing. I have provided a link. I know that the text is a little small. I'll make sure to provide my contact information afterwards in case you have additional questions. Okay, so the difference between Governor Hogan's moratorium and the CDC moratorium is simply how it's interpreted and how long each one is effective. So the CDC moratorium expires at the end of July 31st, whereas Governor Hogan's moratorium expires on August 15th. They're fairly close in expiration date. So for the CDC moratorium, it allows the court to enter a judgment. However, there can be no eviction until after that moratorium expires. For example, if you were summoned to appear at a hearing in July and you raise the CDC moratorium, a judgment may be entered in favor of the landlord, but no eviction can take place until after July 31st. On the contrary, Governor Hogan's moratorium, which expires on August 15th, does not allow a judgment to be entered at all. So if you are a tenant and if you can provide substantial proof of loss of income, which could include a letter of termination from your employer, it could include unemployment payments, anything like that. If you were to provide that to the court is prohibited from entering a judgment against the tenant. However, once these moratoriums lift, the judgments may be entered and evictions may take place. It's also important to note, I mentioned earlier, the moratoriums are not automatic. So evictions are taking place right now, particularly for tenants who are for whatever reason not raising the moratoriums. They don't apply to everyone, of course. So it's important that you apply for rental assistance if you are behind. There's also mortgage assistance as well. So you want to make sure to apply as soon as you can. Okay, in terms of the county bills, so during the pandemic, there were 2 Prince George's County bills that were passed that prohibit certain late fees and rent increases. The first bill that was passed was CB 16-2020, and that essentially prohibits the landlord from increasing rent and from charging late fees. And additionally, after that bill was passed, CB 78-2020 was passed, and it somewhat includes CB 16, but it adds additional information. And it says that no rent increases can take place for a tenant who has suffered a substantial loss of income. However, if the tenant has not suffered a loss of income, the rent may be increased, but by no more than 2.6%. CB 78-2020, it still includes the prohibition of late fees. However, these 2 bills are set to expire 90 days after the state of emergency is lifted. Now, originally, the state of emergency was lifted on July 1st. I believe Governor Hogan may have issued some additional guidance that may have extended that state of emergency. I'd have to confirm, but this is 90 days after that state of emergency is lifted. Okay, so I like to include this infographic before we get into the different types of cases. So it's important to note that an eviction cannot legally take place without a court order. So what that means is if a tenant is behind on their rent, a landlord can't just, change the locks or try to remove their belongings. They'd have to go through the court. What this process looks like is the landlord may or may not provide the tenant with a written notice. It's not always required. We'll talk about when notice is required and when it's not. But what the landlord would have to do is they would have to go to the courthouse and file a complaint. The district courthouse, which is where landlord-tenant cases are heard, they have all of the complaints that are available. All of the complaints that are easy to fill out and that are available in the clerk's office if you are a landlord and you need to fill those out. And so once you file that complaint, the court will then mail a court summons to the landlord and the tenant, telling each of them to appear. At that hearing, the landlord then must obtain a court order and a judgment. Of course, the tenant will be able to raise any defenses that they have. After the landlord obtains a court order, they still have to then apply for what's called a warrant of restitution. And a warrant of restitution is what allows the sheriff's office to actually oversee the eviction. So after this process is held, an eviction can take place. We'll go over the different types of cases and how to potentially prevent an eviction in certain cases. Okay, so if you receive a court summons, the most important thing to do is attend your hearing. Landlords, you are allowed by the statute to be represented by an agent or by an attorney. So oftentimes landlords won't have to appear personally at their hearings. However, if you are a tenant, you have to appear. No one can appear on your behalf. Occasionally people will appear and say, can I have, a postponement because the person who was summoned can't be here. Sometimes that's okay, but you want to absolutely try to attend your hearing because that is the way that you can inform the court of any defenses that you may have. Additionally, you want to try to apply for rental assistance as soon as possible. So there is money that's been made available from the county, from the state, from the city, and I can provide additional resources after today's training. But there is a lag between, the lag time varies. It could be shorter, it could be a little bit longer, but there's a lag time between the time you apply for rental assistance and the time that you receive that assistance. So the key is to just apply as soon as possible. You want to bring any supportive documentations that you have to your hearing. So if you've applied for rental assistance, if you've received rental assistance, if you have proof of loss of income, you want to bring that to your hearing. Okay, so now we'll get into the more substantive types of cases that you may encounter as a landlord or tenant. We'll talk about failure to pay rent cases, tenant holding over cases, breach of lease cases, wrongful detainer, and rent escrow. And for each of these types of cases, I've included a picture of what the complaint looks like, so that way you can know how to identify it if you need to file it or if you receive it. So the most common complaint that our office receives on behalf of tenants is failure to pay rent cases. This is when a landlord is alleging that rent is owed and they want to collect on that rent. It's important to note that when you are filing a failure to pay rent case, you are seeking possession of the property or an eviction. So you're not necessarily seeking a money judgment. The district court in Hyattsville will rarely grant money judgments, which can be used to garnish wages. They're more so going to grant judgments for possession, meaning that if the tenant doesn't pay whatever rent is owed, then they can be evicted. And so I've kind of highlighted sections in which a landlord would have to fill out. This is just important because they can give rise to certain legal defenses. We'll go in more detail in the next slide, but of course you want to make sure it's filled out correctly and thoroughly. And I think we'll just talk about on the next slide. Okay, so the most important thing to note as a landlord is Prince George's County requires that as a landlord, you obtain a rental license. And what this process entails is you go to the county, you apply for a rental license, which requires you to pay a fee. I believe it's about $90. Once you pay that fee, a temporary license is issued. And then after obtaining that temporary license, you then have to have the property inspected. This just ensures that the property is up to code. This is required because there's case law that says that if you don't have a valid rental license, that you cannot proceed with a failure to pay rent case. That means if you were to file a failure to pay rent case, it could be dismissed on the day of your hearing. So it's important to note that if you have that rental license, you want to bring that to court and make sure you have it before your hearing. Okay, the next requirement for the failure to pay rent case specifically is, as a landlord, you need to have what's called an MDE license or certificate. So if your rental property was built before 1978, you want to make sure that it has been inspected for lead paint and that you receive some type of certification stating that it has not been affected by lead paint. Again, that's required for the failure to pay rent case. And a lot of these are technical, but it's just one of those things that you would need to do in order to succeed on this case. So potential defenses to failure to pay rent cases are if you raise one of the moratoriums, if the complaint is incomplete or signed, if there's no rental license, a landlord must have a rental ledger. As a landlord, you want to make sure that you keep a good accounting, keep any receipts, keep note of any payments that you've received and the dates of those payments. Likewise, as a tenant, you want to make sure that you keep a copy of your payments, of your receipts. That way you can bring those to court and hopefully be able to reconcile anything that is alleged that is owed. Okay, so it's important to note that for a failure to pay rent case, even if a landlord obtains a judgment against you, as a tenant, you do have what's called the right to redeem the property. So what that means is if your landlord takes you to court in July, and if they are successful and they obtain a judgment, you still have the right to stay in that property, provided that you are able to pay whatever amount is requested on that judgment. So that's why it's so important to apply for rental assistance as soon as you can, because just because there's an eviction judgment doesn't mean that you will be evicted. If you can come up with that money. The only time that you would not be able to redeem the property or pay to stay is if you have 3 or more failure to pay rent judgments within the past 12 months. If you have 3 or more, your landlord can request that your right to redeem be forfeited. That's important to know. Okay. So we've talked a little bit about failure to pay rent cases. Now we'll talk about tenant holding over cases, which we're starting to see a lot more. So because we've been in this COVID world for over a year, a lot of people's leases have expired. So what landlords can file now are what's called tenant holding over cases. What that means is the landlord is alleging that your lease has, or that there is a lease, that they have given you written notice saying that they want you to be out by a certain time, and that you continue to reside in the property and that your lease has expired. This is a very technical case. There's not a lot of defenses to it if your lease has in fact expired. A lot of times it just comes down to whether or not the notice was sufficient. So it's important to keep in mind that if your lease has expired, at any given time, your landlord could file one of these cases. In Maryland, there is technically no requirement that your landlord renew your lease. So it's important to get clarification as to whether when your lease expires, if you'll continue as a month-to-month tenant, or if you'll continue on a new year. And essentially, I think I pretty much went over what's required for this case. There has to be a valid lease. That could be written or oral. Of course, oral leases are hard to prove, but they are recognized in Maryland. Additionally, your landlord has to provide written notice. They have to show that your lease has expired and that you continue to live in the property. Okay, and breach of lease cases, pretty straightforward. We often see these for like cases in which dogs are prohibited in the property, or if there's some type of criminal offense, a landlord may file what's called a breach of lease complaint. For these cases, I advise tenants and landlords to just review the lease to see what is actually considered a breach. For this case, your landlord would just have to show that there is a valid lease, that they have given you notice of the alleged breach, that breach is substantial, and that it warrants an eviction. And again, those are pretty technical. That's what your landlord would have to prove in court, and that's what the complaint looks like. Okay, in wrongful detainer cases, this is considered a squatter's right statute. So essentially, this is for like house guests or people who you have given permission, but they really have no type of ownership interest in the property. So if you allow a friend to stay for a couple of months, but then they refuse to leave, this may be filed. I mean, it's important to note that in Maryland, an eviction cannot take place without a court order, even if this person has no legal right to your property. So yes, yes. So even if, this is just a house guest, they're not our owner, you still would have to go through the court. Also, it's important to note that if the court grants someone possession of a property through a court order, we see this a lot in domestic violence cases. sometimes the victim will be granted use and possession of the property. That does give you legal right to stay in the property. In this case, could not be used against you because you have a legal right to be there. So this wouldn't apply to someone who's a homeowner, who's a tenant, or who has been granted possession of the property through court order. Okay, I believe this is last, and essentially one of the most important, and this is called a rent escrow case. So essentially, this has nothing really to do with eviction. It's more so what tenants can do if they are dealing with issues in their property to which they've given their landlord notice, but those defects have not been fixed within a reasonable amount of time. So for rent escrow, what it requires is that you first give your landlord notice and an opportunity to repair. So if you have no heat or if you have like a rodent infestation, you have to bring it to your landlord's attention and you have to give them some type of time to repair. And of course, the nature of the circumstances are going to depend on, what's considered a reasonable time will depend on how much notice is required. And so once you give your landlord notice of these defects, if nothing is done, you can file what's called a rent escrow case with the court. This just allows the tenant to pay their rent to the court, and the landlord would then be summoned or ordered to fix any defects in the property. And essentially at the end of that case, the tenant could receive a portion of the rent that they paid to the court. Vice versa, the landlord, you will usually receive a portion of the rent based off of what issues they have repaired. Okay, and that's pretty much it. I have included a list of helpful resources. I've also made my contact information available, and I'm happy to answer any questions that you have. I didn't want to make it too substantive for you, but I'm happy to go in more detail if you need me to.
Thank you very much, Ms. Williams. We really appreciate that. And we do have some questions. We have hundreds of people watching on Facebook. And this is from one of our Facebook viewers tonight. They said, is it the case that seniors who rent must be given a 2-year lease? And if so, is there a limit on the amount of increase the landlord can add to their lease? So yes, the county does have a statute that requires certain landlords to provide seniors with a 2-year lease. Now, it only applies to certain homes. I don't have the statute in front of me, but I will say it applies to certain residential facilities for seniors. In terms of that 2-year lease period, your rent is, it cannot be increased during that 2-year time period. Okay. Thank you very much for that. Before I have an audience question, but I want to make sure I give the people who are watching at home the phone number if you'd like to call in your question and ask our panel tonight. We will even take a question about COVID-19 if you want to call that in. That phone number is 240-294-1308. And don't forget, you can also put your questions in the chat box on Facebook Live, and we'll get those answered for you as well. And anyone in the audience who'd like to come to the side microphone to ask their question, you're welcome to do that as well. This is a shy audience member. I'm going to ask their question for them. They say, does the prohibition on late fees apply to condo fees as well?
So condo fees are interesting, and I haven't done my research on condos as thoroughly as I have on tenants, just to be honest. But as a condo owner, you are a homeowner. So it kind of varies. Oftentimes that will deal more so with the homeowner association requirements. But I will say, if you are renting to a tenant, the prohibition on certain rent increases applies. I can't speak directly to the specific condo fees.
Okay, thank you very much for that. We are taking phone calls, and I have someone on the line that would like to ask their question. Caller, go ahead and ask your question.
Okay, thank you so much. This is great information. If I receive rental assistance, do I still need to attend my court hearing?
That is a very good question. Yes, absolutely. Because You want to let the court know. You want to also let the landlord know that you have received rental assistance. What we see in court is a lot of times the person that you may be interacting with at your rental property may be someone completely different than who appears at your hearing. And that person who appears at your hearing may know nothing about what's going on in the back end in terms of what assistance you've received, what you have paid. So that's why it's important to be able to advocate for yourself and to show proof that you have received rental assistance. It's also important to note that I believe a requirement from the county to landlords who have received rental assistance is that the landlord agrees to dismiss any pending actions against the tenant and also agrees to waive their right to file any eviction proceedings for 90 days after receiving those funds. So if you don't communicate that information to the court may very well enter a judgment without knowing.
This is interesting. Can my landlord charge me for rent after I move out?
So that's a good question. And I think that depends on your lease, and it also depends on if there's an outstanding balance. So I mentioned earlier that there are two types of judgments that a landlord can receive. One is a money judgment and one is a judgment for possession. So if a landlord is seeking to evict someone, they're going to seek a judgment for possession. However, if they are really just interested in the money, they could go to Upper Marlboro and request a civil case be filed and try to obtain a money judgment. We often see these cases filed when a tenant either leaves early or if they leave with an outstanding balance in which the landlord can file a money judgment. So it's possible that a tenant can leave the property and still be sued civilly, even though they've avoided an eviction.
This is actually a question for Dr. Unebu, and I want to ask you on behalf of a parent. They're saying their child is only 11. Should they stick to the CDC guidelines that are saying that the vaccines are only safe for children 12 and up?
Yeah.
People are getting antsy, I guess.
Yeah, but they are getting antsy, but that's a good thing. Unfortunately, they will have to wait. Just follow the guidelines. And he says from 12 years or older. Yeah.
Okay. Thank you very much, Dr. Yu. Mayor Mo has a question. Go ahead, Mayor.
Actually, I want to give a scenario that we ran into here. I think it was at least twice where it's about the renewal. And my question really is, how long is there a certain time for the renewal? They were trying to pay their, get rent assistance, but the landlord told them that they were waiting for their renewal before they would do anything. Is there anything that can be done? Is there a time limit?
Not necessarily. So when it comes to leases and renewals, the tenants really don't have a lot of bargaining power. A lot of that power resides with the landlord. And the landlord can pretty much decide whether or not to renew or not to renew at any given time, unless their lease specifies that they have to do so within a certain period.
Yeah, I want to say that this individual had about another 2 months left, and they were being advised that they weren't paying their rent, and they were told they weren't going to be renewed. Is that the easy way of kind of getting rid of someone that's renting?
Yes. Unfortunately, okay. We're starting to see that a lot more.
Okay, thank you.
Thank you, Mayor Mo. We do have a caller on the line with a question for our panel. Caller, go ahead with your question.
Hi, if I have to go to court for non-payment of rent, what should I bring?
Sure, that's a good question. So you want to make sure that you bring, of course, your court summons. That will allow legal advocates to be able to know what your landlord is asking for. And also, we do a lot of negotiating in the hallway with the landlord's attorneys or with their agents. So if we can see exactly what's being requested, perhaps we can negotiate on the tenant's behalf and try to reach an agreement. Additionally, if you have your lease, you want to bring that. If you've made any payments, you want to bring proof of payments. you've received rental assistance, you want to bring that. If you have suffered a loss of income, you want to bring any proof of that. So that includes letters from employers. It can be anything like you were hospitalized and you lost your job, anything like that. If you plan to raise the moratoriums, either the CDC or Governor Hogan's moratorium, you want to bring the declaration form, which applies to the CDC, and you want to bring any supporting documents of loss of income to raise Governor Hogan's moratorium.
Thank you for that. This looks like a landlord question. The question is, do you need to have a rental license with Prince George's County in addition to the rental license with the city in which the rental property is located?
I think that varies depending on the city that you live in. I think if the city requires it, that should be sufficient.
They would come for their renter.
So you would just bring in your city license to the court if you were summoned to appear.
You may have answered this already, Ms. Williams, but I do have a question. They're asking, is a notice to vacate enough to evict someone?
Good question. So no, it's not. And a lot of landlords will provide their tenant with a notice to vacate, which is okay. That is simply to put the tenant on notice that either the landlord wants the property back or that an amount is owed. But it is not sufficient to evict a tenant. So it's simply to put them on notice. If the tenant stays beyond the notice period, then the landlord has to file a court case. So what this looks like is if a landlord gives a tenant a notice on July 1st and says, I want you to be out by July 31st, if the tenant continues to stay there on August 1st, the landlord can't just come and change the locks. They have to file a court action. And landlords, it's important to know that there's a statute in Maryland that prohibits evictions without a court order. If that does happen, you could potentially open yourself up to be sued for an unlawful eviction.
Councilman Sidner, I know you had a question.
Yes, Ms. Williams, you already answered this question already, but I think it's worth clear it up again. So you say that a relative come move in my house for like 6 months or something, and all of a sudden now our relationship get bad and I want him out of the house. He didn't sign no rental agreement, nothing legal, just me doing a good favor for the relative. I cannot put that individual out.
That is correct. That is correct. And I know it seems crazy, but that is the law in Maryland.
Sounds like he has a visitor.
Yes, that is correct. And that's why it's important to, if that is the case, you have to get the ball rolling as soon as you can, because, you have to wait for the court, fortunately. Now, and also we see this a lot with foreclosure cases, unfortunately. So foreclosures are supposed to happen in the circuit court, but there's some case law that kind of allows the district court to deal with these cases. So oftentimes after foreclosure, the bank then owns the property, but the homeowner will still be in the property. And the bank then files a wrongful detainer case and says, hey, this person has no contractual relationship with me. I want them out. And oftentimes they're successful. Just something to keep in mind.
This sounds a little odd to me, but can you negotiate with your landlord for back rent so that you don't get evicted, or are people doing that?
Absolutely, and that's a great idea. I often encourage landlords and tenants to try to reach a resolution. It is ultimately up to the parties because when you have a lease, that's considered a contract. The only way to get out of that contract is to reach an agreement outside of that. But if you do reach an agreement, I always encourage both parties to put it in writing, because if it's not in writing, it didn't happen. And then also, if it is in writing, you have something to show the court if you ever need to.
Anybody in the audience have a question that you'd like to ask? We can take a few questions from the audience. And once again, I want to give the phone number for people to call in. It is 240-294-1308. If you have just been kind of like most people, just weathering this pandemic, you still were working, you had rent, you just didn't pay. Are some people under the impression that just because you decided not to pay, that for some reason you're going to be able to stay in that place and keep living there? Are there, because it seems like people think that I just didn't pay and I'm hearing about all these moratoriums, so they don't want to give up the money.
Yeah, and by doing that, you put yourself in a very unpredictable situation. Because, like I said, the moratoriums, for one, they're not automatic. So they're not going to apply in every case. And two, they're not going to prevent rent from being owed. So even if you weren't to pay your rent, and even if your landlord said, I'm not going to evict you, they could always go file a civil case and obtain a money judgment. And that means they can garnish your wages, things like that. So again, your lease is considered a contract. So it's important, you want to try to pay as much as you can when you can. Unfortunately, we occasionally have clients that see us in district court, and that's what they'll tell us. It's, the moratoriums don't necessarily apply because they haven't suffered a loss of income, but they just haven't paid. And then that puts us in a position where we can't really raise those moratoriums because we're having to put that on under oath. So unfortunately, you could obtain a judgment against you for something that could have been avoided. So if you can pay, I would recommend that you do.
Councilman Sidner has a question for you.
Yeah. Follow-up question here. Say the rent is $1,500 a month, and then the person said I only can pay $500, but the landlord say that I can't accept the $500. How does that process work?
So I, as a tenant advocate, say that the landlord should not be doing that. And occasionally I'll run across leases that say that landlords will not accept partial payment. The issue that I have with that is, by law, as a tenant, you have the right to redeem the property, meaning you have the right to pay whatever amount is owed to stay in the property. So if a landlord's denying you the right to pay whatever amount that you have, arguably they could be waiving your right to redeem. So I would say, if that happens, to probably give us a call and we can walk you through the process. But also, you want to bring, if you have payments that your landlord is refusing to accept, you want to just make sure that you keep those. And if you have to appear in court, bring those to a court hearing, because sometimes we will have tenants pay whatever amount is owed to the court directly.
We're approaching the top of the hour, so I want to give people a chance to get your contact information, Ms. Williams. And we do have a graphic that has those phone numbers and things, but go ahead and let people know, because this is a lot of good information. But I imagine if you're going through something like this, it's very frightening. You're worried about having a roof over your head. You have no idea where to start. So how can people get some assistance from Community Legal Services and yourself?
So you can call us, you can email us. I have business cards. I'm happy to give everyone my contact information. Again, if for some reason you can't get a hold of us before your court hearing, you can always just show up to the Hyattsville District Court, and we are there to provide same-day representation. We can provide legal advice to anyone, no matter what county you live in or no matter what your income is. However, we can only provide representation to tenants who meet a certain income guideline. So you're welcome to call us with questions, or, even if you've been to court previously and the landlord was successful and you have since obtained rental assistance, that's something that you may want to inform the court. And we're happy to be able to help you potentially file a motion or raise the moratoriums on the back end.
And the email address is info@clspgc.org.
Yes, that's correct.
Okay. And any phone number that you'd like to give the audience that's listening tonight?
Yes, our office number is 240-391-6370. You can also visit our website at www.clspgc.org. And on our website, you can apply for services, and that way you can list out any type of information that you want us to know before you contact us.
And you also, we have a graphic with your resources that's on the screen for people who need any of that information that you just gave. It's on the screen right now. But here's the good thing for people who are listening at home, watching on Facebook. This event has been recorded, and it's going to go up on the Laurel TV official YouTube page by tomorrow morning. So no matter when you want to take a look at the information, because there was a lot to go through, get on that Laurel TV YouTube page, and then you can watch it at your leisure. Fast forward and find the answers to your questions. Get those phone numbers, get those email addresses if you have other questions that you'd like to ask. So, Ms. Williams, thank you so much for being with us tonight. This was so informative, and we are so thankful that people can get some information about how to keep a roof over their heads, because people have been through so much. The last thing you want to do is to now be trying to look for someplace else to live.
Absolutely.
So I'm Communications Director Audrey Barnes. On behalf of my team, we want to thank you all for watching. Have a good evening, everyone.